All right, excellent. Let's start off with Senate Bill 78 with Vice Chair Wallstreicher.
Thank you, Mr. Chairman. Senate Bill 78 prohibits a law enforcement officer from administering ketamine to an individual or directing an emergency medical service provider to administer ketamine to an individual. An EMS provider may administer ketamine to a severely agitated individual if, one, the individual is combative, violent, and represents an immediate danger to the individual or others, and two, the EMS provider first obtains medical direction with specified exceptions. There is an amendment in your packet. This is Amendment 573-128/1. This is for Senate Bill 78, Amendment 573-128/1. What the amendment does is it strikes provisions of the bill and instead creates a reporting requirement. It provides that, and if you're working off of the reprint, this is page 1, provides that on or before October 1st, 2022, and each October 1st thereafter, the Maryland Institute for Emergency Medical Service Systems shall collect data from state and local emergency medical service providers on the administration of ketamine to individuals by emergency medical services providers in the prior 12-month period. It also provides for what data should be or needs to be included in that, and on the next page provides that there needs to be a report to the General Assembly, the President of the Senate, and the Speaker of the House and the Senate Judicial Proceedings Committee, as well as the House Judiciary Committee, on or before December 1st, 2022, and each December 1st thereafter.
Thank you, Mr. Chairman. So this strikes the bill, and I appreciate Senator Cassidy and those who raised concerns about the legislation. So it strikes the bill and just replaces it with a reporting requirement. For those of you who are around, that's what we did with SWAT, and I think it had a good result. And so I spoke with Ted, let me get his last name, Delbridge from MIMS, and he was okay with the reporting requirement. With that, Mr. Chairman, I'd move the bill. Move the amendment.
First, let's adopt the amendment first.
Sorry.
Go ahead, Council first, and then we'll adopt the amendment.
So just wanted to point out also on page 3 of the reprint, this does have a sunset. So it would be effective for 3 years and 3 months, and then at the end of December 31st, 2024, it would sunset.
Senator Cassidy, did you have a question?
I don't have any problem with where we're going with this. I'm just, in collection of the data, it doesn't really specify, but I don't think that, I'm not sure that MEMS can collect health data if it's unless it's aggregated so that it doesn't disclose the patient. And I'm not sure that's what this does, that your intent isn't to disclose the patient.
No, the intent is not to disclose the patient, correct?
I'm just looking at the way it's written. It doesn't say, it says for each individual. Data shall include to each individual. I don't see anything in there that makes it clear that we're not.
Like apply there, so I don't know that it necessarily needs to be said that it can't. I just think that they wouldn't be able to because that's protected health information.
Okay.
What about any other type of PII?
I'm sorry?
Any other types of personally identifiable information? Like, does it have to be, do you have to put something that says it has to be anonymized, or?
I mean, you could, and I know this session the committee's used language like that, so I could add that in concept.
So, sounds good. Okay. So we adopt the amendment. Is everyone okay adopting the amendment? All right. Amendment's been adopted, and so now the bill's before you as amended. Is there a motion? Motion favorable, seconded. Everyone's okay? Great. All right. Great. Let's move on to Senate Bill, Senator Bailey, Senate Bill 268.
So Senate Bill 268, as introduced, this bill alters the definition of a crime of violence under 14101 of the criminal law article to include sexual abuse of a minor under specified circumstances when the offender is an adult and the victim is a minor younger than the age of 16 at the time of the offense. There is an amendment in your packet. This is for Senate Bill 268. That is Amendment 228475/1. That's Amendment 228475/1. And going to the reprint, this would provide if you go to page 3 of 3, this would keep the current bill language, but it would also provide that a person who's subject to lifetime sex offender supervision would also include, so currently a person who has been convicted of sex abuse of a minor involving a child under the age of 12 is subject to lifetime supervision. This would provide that a person who's been convicted of a violation of that offense involving a child under the age of 16 would be subject to lifetime supervision. And additionally, it has a provision for prospective application that was consistent with information that came from the Attorney General's office. It has a provision at the end. It's on page, actually it's after page 3, provides for prospective application. After speaking with the AG's office, there'd be ex post facto considerations if the law were to go back and retroactively apply.
I'll just ask Gene. Gene, what's 3-602?
Thank you, Mr. Chairman. So when we talk about this bill, what we're talking about is it is left exactly as it's introduced when we're talking about 268, which simply changes the age from under 13 to under 16 for sexual abuse of a minor under very specific circumstances when the offender is an adult. It makes no changes to those circumstances. The only thing it does is it says if the child is 13, 14, or 15, it is the exact same as if the child was 12 or under. The amendment combines a portion of the bill, the sexual offender's lifetime supervision, into the bill. And the reason that that was done is in consultation with counsel, in consultation with the people that were the victims of this crime. This relates back to the crime of sexual abuse of a minor under 3602 of the criminal law article, and because with the amendment we are setting a uniform victim age of under 16 for both the crime of violence and the lifetime supervision.
Are you going to make a motion to adopt the amendments? All right.
Make a motion.
All right, second. Everyone's okay with that? All right, so now, bill's before you as amended discussion. Everyone knows what the bill does. Senator Carter, go ahead.
With the amendments, what exactly does the bill do?
So it alters the definition of crime of violence under 14101. So those are the penalties, the mandatory penalties for subsequent offenders, but It also affects who's required to register for lifetime supervision under the lifetime supervision statute. And for that, it would increase the age for individuals convicted of sex abuse of a minor. Currently, lifetime supervision applies to an individual who has committed that offense involving a child under the age of 12. So this would raise that to an individual who's convicted under sex abuse of a minor involving a child under the age of 16.
Does sex abuse of a minor include statutory, or it's definitely a violent crime?
So-
Like first-degree sex offense?
That statute defines sex abuse as, it's enumerated, so incest, rape, sex offense in any degree, and unnatural and perverted sexual practices. I think the statutory would fall under second degree.
Or it would fall under sex offense in any degree?
Well, I guess it's second degree rape. That's the age difference where there's more than, it's 14 and then more than 4 years, I believe.
Well, briefly, committee, does anybody else not see that as a problem?
So I can explain.
To have a lifetime sex offender registry for someone that could be convicted of sex? Go ahead.
So that's not correct. So what it does is it says the person in a position of authority, right, to be able to have that apply. So we don't want to confuse that with care or custody or responsibility for the supervision. So it would be, the only time that would apply, I'm going to give you an example, like a teacher that was in school that was having a relationship with somebody that was 4 years younger. Now, it's not 17 and it's not 16. It's under the age of 16.
I have a question, if council could answer. So does that mean like a 15-year-old and a 19-year-old? So a 19-year-old who has a sexual relationship with a 15-year-old could be under lifetime supervision?
So for second degree rape, it provides that a person may not engage in vaginal intercourse or a sexual act with another if the victim is under the age of 14 and a person performing the act is at least 4 years older than the victim. The 15 and right, that's the current law.
Right, but under this bill.
So I'm trying to think about the situation with the 15 and the 19. Let me just look at the statute and can I get back to you? No, well, as far as the lifetime supervision, if the victim was under 16, then yeah, but I just want to double check on what the scenario that you just gave would actually fall under as far as the rape or sex offense statute.
Thank you.
I just was going to clarify from talking with the state's attorneys about this case. They said the case law concerning the exact matter is rather clear, and they said it can only be charged if the facts arise to the person in a position of authority, and it cannot be confused with the care or custody or responsibility for the supervision as defined in case law for sex abuse of a minor.
Thank you. First, Claire, are we talking about lifetime supervision or lifetime registration? Talking about like lifetime parole? What? First, I thought it was like just sex offender registry, but it's not. It's lifetime supervision.
Right, it's lifetime supervision.
So let me ask, can I figure out why we want to do this? What's the problem with just leaving it up to the discretion of the court as to what length of time the person should be under supervision? lifetime supervision is long. It's not, so at first I thought it was just registration, and I thought that was probably too over the top. But lifetime supervision under the jurisdiction of the courts for life?
So I would tell you that if you remember the hearing, you remember not only the victims that came in, but you remember the attorneys that prosecuted the cases that came in. And one thing when we talk about people that are sexual predators of minors, they repeat their crimes more than any other crime. They are bound to do it again. And what we have right now in Maryland is we have a situation that there are people that are not on the registry. And the fact is, when we talk about how do we combat this with law enforcement, without the registry, and if you remember the way this bill was introduced several years ago, we introduced this bill to try to extend probation, because it's 5 years probation, because of the fact that when you see a person after they get off of probation, and that's what you saw a couple of the witnesses testify to, all of a sudden these people that had gotten off of probation were now at schools. They were targeting young children. They were in the process, and there was nothing that anyone could do without lifetime supervision to adjust that person's conduct until they committed another offense against a child. That is what is so imperative about this. This has to do with offense against a child, and it gives, without arresting that person, it gives that ability for them to correct their behavior. They can give them an order to say, you know what, you shouldn't be around this school. You shouldn't be going by this daycare facility 8 times a day, right? That is how, and I think that was very clear in the hearing, that this is the way that the experts in this field think that it's the best way to handle it.
Struggle with
Let's go ahead. We're gonna keep working on this. We'll hold it for now. Okay. We'll come back to this. All right. So let's do that. We'll go on to, let's go to Senator Jackson with Senate Bill 608. Senator Lee's next.
So this bill updates and modifies requirements and terminology for MPTSC relating to membership, procedures, and training of police officers. Among other things, the bill requires that MPTSC conduct job task analysis for entrance-level police officers every 10 years. In the fiscal note provides a fairly comprehensive list of the aspects of the statute that are altered by the bill. There are about 23 different bullet points that are covered as far as what the bill is altering.
Thank you, Mr. Chairman. Thank you, Jamie. So, colleagues, what you have before you is the culmination of House Bill 1016. After the Freddie Gray incident in Baltimore, the presiding officers decided that we need a public safety and police work group. Those who were on the work group traveled the state. We had stakeholders from advocates to public safety officials to academics, academicians, and House Bill 1016, out of House Bill 1016, let me back up, the Maryland Police and Training Standards Commission was created. And with that were some directives. Now, all of those have been created. They were published. They were voted upon. 4 of your members in the General Assembly sat on that commission. That was part of the creation of MPTSC. This was voted out of the House unanimously last year, but it got caught up in COVID. And we did not have a cross-filer. And so we've been working with Jamie, we've been working with the Training and Standards Commission to get the verbiage the way it needs to be. This is the bill we have before you.
Just have a quick question for the, for council and for the sponsor. So good to go, but is this, we obviously have a lot of work to do on police reform because we've got to do the conference committee, but is this consistent with the discussions that we've had? Is it consistent with the discussions we've had?
I believe so. It does make some changes to the training statute and reorganizes the training statute, but I believe those could be reconciled with whatever the General Assembly decides to do with police reform. I do want to note that there is an amendment in the packet that does overlap with some of the work that the committee had done earlier. It does provide, if it's in your packet as Amendment 483424, and it just provides for training to include training in the alters the current training standard for use of force. So if you look at the reprint, page 9, would require the curriculum and courses of study to include training in the use of force, de-escalation, that's in the bill already, and then the new languages, and the duty of a police officer to intervene when the police officer observes another officer using force that is excessive or violates the use of force policies of the state or the law enforcement agency that employs the police officer. There is also a change on page 6. This looks technical. It's providing that the commission shall establish standards for the approval and continuation of the approval of each school. So it strikes the current language that says schools that conducts police entrance level and in-service training courses required by the commission, including each state, regional, county, and municipal training school. So that is technical.
I'll defer.
Never mind.
Wrap it up. I think, thank you, Mr. Chairman, and thank you, Jamie, for the overview. We know we have a lot of work to do in police reform. However, we cannot, disregard the work that has been done prior to that. This puts a pin in that, and we're in a position where we can pivot and add what we need to the public safety article going forward, whatever the end product is. Some of the things that we've talked about over the years since 2016, 2017, the Training and Standards Commission has been working on, and Senator Huff, myself, and I think Senator Smith may have been a part of that as well. So that's for the favorable, move the bill favorable.
I guess for council, if you can look on page 13, this is the original bill. I wasn't looking at the reprint. On page 13, the original bill, section 3209, just trying to understand sections A and B. I'm sorry, sections A1 and 2. A1 says a law enforcement agency may employ an individual as a police officer for a period exceeding 1 year only if the individual is certified by the commission. And then number 2, a law enforcement agency may employ an individual as a police officer for a period exceeding 1 year only if the individual is provisionally certified by the commission.
Right. So that would, the way that that's drafted, it's requiring that the commission give that the individual be certified if their employment exceeds 1 year. Otherwise, they couldn't be employed
More than
for
1
that
year.
period. But it would need to, I think that the distinction there is that it's a provisional certification for anything up to a year.
So number 2 really means law enforcement may not employ an individual as a provisional police officer or something
Right,
like.
right.
Okay. And can I just also, it doesn't look like there's any opposition to this at all, and I assume that all the various police departments and agencies got a chance to review this, and
Yes.
everybody, you have universal buy, I mean, but when I'm looking at the file, there's universal buy-in, because I don't see any opposition by any of the
Yes.
many police agencies throughout the state.
Yes, Senator. The Police and Training Standards Commission has representatives from the police of the state, sheriff's police, municipal police agencies, FOP. There's another law enforcement organization, federal partners, AG's office. 4 members of the legislature sit on that, and 4 civilians. And each and every one of these processes, provisions that's in here, went through the process of being publicly published. Sorry. And then, so at each provision, it got published for public comment, and then it was voted on at each session, and before the final document was submitted.
Well, I commend you on that process, on getting such universal buy-in on a topic that's, fraught with such political disagreement these days, so great job.
I appreciate it. Let's see what the next step has. So, can I get a second on my? Thank you.
So that's on the amendment, so it's adopting the amendments. Everyone's okay with that? Okay, great. All right.
You'll be doing the next one.
Further discussion on the bill?
You'll be doing the next one.
Is there a motion for favorable? With amendments? It's been seconded. Is everyone okay? All right.
Mr. Chairman, Senate Bill 607. Okay, all right, thank you.
Yes. Sure. Do you want me to say anything, or do you want to talk about what the amendments do now?
So the bill, as introduced, it alters the provisions for when an individual is disqualified for jury service. So under the bill, it says an individual is disqualified if they have been convicted in a federal or state court of record of a felony and is currently serving the sentence imposed for the conviction, including any term of probation. Therefore, it removes the requirement. It goes from the currently law says the individual has been convicted in federal or state court of record of a crime punishable by exceeding 1 year and receiving a sentence of imprisonment for more than 1 year, or has a charge pending in federal or state court of record for a crime punishable by imprisonment exceeding 1 year. So it goes from the 1 year to felony. So the amendment, it was not passed out to you. So the amendment in the packet is incorrect. The amendment that's currently proposed would read, in line 7, number 4, the individual has been convicted in a federal or state court of record of a felony, 1, received a sentence of imprisonment for more than 1 year, and 2, is currently serving the sentence imposed for the conviction, including any term of probation. Or 5, has a charge pending in federal or state court of record of a crime punishable by imprisonment exceeding 1 year. Should that just, so recent went from felony to here, should that just be removed? So it's just felony? Okay, so, correction. So it would read, an individual is disqualified for jury service, or the individual has been convicted in federal or state court of record of a felony, or oh no, it does, sorry. Here. The individual has been convicted in federal or state court of a felony and is currently serving the sentence imposed for the conviction, including any term of probation. And then number 5 is just reverted back to current law, has a charge pending in federal or state court of record of a crime punishable by imprisonment exceeding 1 year. Does that make sense? 4 in its entirety is, has been convicted in federal or state court of record of a felony and is currently serving the sentence imposed for the conviction, including any term of probation. It basically takes the language from lines, the added language from lines 11 to 13 and puts that into 4.
Has a charge pending? 5, what does 5 say now?
5 is current law. Nothing happens to 5. It goes back to what it current law is. So the bill language, the new additional bill language would be struck, so that way 5 would stay what current law is. Has a charge pending in a federal or state court of record for a crime punishable by imprisonment exceeding 1 year.
Okay, well, so here's my question. Comes back to what I asked yesterday. We had the word crime there, but we've now replaced that with felony. Suppose they're in jail for a misdemeanor. Can they be called to be a member of a jury if they're incarcerated for a misdemeanor and therefore would be brought into a courthouse in handcuffs to serve on the jury?
So I shared your concern yesterday, but after talking to counsel, I realized that that's a problem under current law. And under current law, no one in jail is getting called for jury service. No one has expressed that there is a problem with this, that is a common thing, or that it is a thing that happens ever. And so to the extent that there is a gap in current law that doesn't cover that, but no one has expressed a concern that that's occurring, I'm convinced by counsel that there's nothing for us to do here.
All right, so we'll just let it ride until a problem presents itself, and then we can deal with it.
You have a state's attorney that is very active in contacting us
Yes.
in many different
Yes.
fashions. I think we might hear if that occurs.
Okay. That's fine.
So when I'm looking back at the original bill now, so really what it does on number 4, currently the original law says has been convicted of a federal or state court of record of a crime punishable by imprisonment exceeding 1 year and received a sentence of imprisonment for more than 1 year. And now what we're saying is, instead of saying a crime punishable by more than 1 year, we're saying a felony. And
So if an individual has a conviction, they're only disqualified if it's a felony, and they're currently serving the sentence for the conviction, including any term of probation. However, if they have a pending charge for whether it's a misdemeanor or a felony, it's what current law is. You have to look at what it's punishable by, a term of imprisonment exceeding 1 year.
we would, you got a sentence of more than 1 year, whether that was a felony or a misdemeanor, I'm understanding why we would just differentiate between that. There's some really bad misdemeanors out there, and a misdemeanor, you could have gotten 10 years on a misdemeanor, and we're just saying, and maybe 1 year on a felony. Just depends on what they plead to or whatever. And we're differentiating, we're saying it's a felony. I don't understand why we wouldn't just leave it with the crime punishable by more than a year, so you knock out all the little stuff. Because and then you're adding in, and you're currently serving the sentence. Because you're still requiring that they're currently serving the sentence imposed, right? You're letting them serve on the jury. If they've been charged and they've done the time, and then you're letting them serve on the jury once they've finished the term, why would we just differentiate between a felony and a misdemeanor? We're saying you can come back and serve right away as soon as you're done your time. But we're differentiating between a felony and misdemeanor. I don't really understand that, because I thought that was the whole purpose of the bill, was to say, we got people out. I mean, when we hear the evidence on this bill, we got the guy who's been out of prison for 30 years. He did time 30 years ago, and he's back. He's a father. He's working a decent job. He's been working this job for 20, 30 years. He's had no further interaction with the law. I got a lot of sympathy on that, right? You won me over on when those guys come and testify. Boom, I'm right with you. But then we go from that, and we say, well, as long as you're, if we're going from there all the way back to the guy who got 5 years for all kind of misdemeanors and is still on probation. Hell, he can still be doing time, I guess, the way this reads. But we're saying they don't bring him out of prison, so still on probation, and they can come right back in. We can do what you're going to do. I just don't follow the logic, because we dangle these really tough cases out there. They're really compelling cases. We dangle those out there, and we go from there all the way back to just squeaking through, just squeaking by, and that's sort of a habit we do. I think. Well, thank you.
To be quite honest with you, now Senator Castley has confused me, and I apologize. It's hard. I'm not making excuses, but it's hard because we've been back and forth. I thought that we were continuing to exclude someone who has not completed a sentence. Is that not correct? Okay. Serving a sentence imposed for a conviction, including any term of probation.
Only in the instance the amendment is for a felony. So if you were convicted of a felony, then you would fall
okay.
under
So
that.
if you're just on a misdemeanor probation, then it's fine.
Correct.
And it probably should be, right? Like what's?
I thought we went to that yesterday.
So I'm happy with the bill, and let me explain. I think that even Senator Castley is saying he's okay if someone has a prior felony conviction, which, according to data, 33% of black men in America have it, so they're excluded from serving on juries. We know that we have a high incarceration rate here.
You said 33% of black men have a felony?
In the United States.
No way.
Conviction.
No chance that
Okay, let me just-
33%, that's millions of people would have a...
Okay, let me read this. Let me read to you.
No chance.
I think it was the Prison Policy Institute, is that 33% of African-American men serve time in jail during their lifetime.
Okay, so it's not a
So
felony.
you could be for a misdemeanor, but still.
There's no chance
Wait, but let's be clear. Most people are not serving incarceration. So we know that Maryland has this exceedingly high
There's no
incarceration
chance
rate.
that 1/3 of
Nobody
what
in
was
our
said that was
prisons-
served a felony. Felonies are, well, they should be rare. There's just no chance that
No
1/3
one
of
in
black
pri-
men have been convicted of a felony. That was what. Okay, that's what Senator Carter said, and that's what I was correcting. And the other
You're right.
stat, I would have to look, you're saying a third of all black men have been convicted? I'd have to see that study too. Have served time in prison?
Okay, I will clarify.
Let me see
what
that
the
study.
report
All
actually
right, let's
says.
go ahead and let's hear Senator Carter, and then let's clarify what the amendment would do on the bill.
What it says is that 30, well, that approximately 33% of black men are excluded from a jury pool because of a felony disqualification. So you're right. It could be different, because this is not just based on Maryland, so it could be different in other states. So let me be clear, to the extent I can. According to data, there are over 20 states plus District of Columbia that no longer exclude people that have prior felony convictions for serving on juries. Many states have varying laws, like Maryland does, like certain convictions keep people off, certain pending charges keep people off. But there is a trend ever since most of the country, and Maryland led the country to some extent, in allowing people that had felony convictions to vote. There's been a trend to also re-enfranchise them in terms of serving on juries. So I would urge the committee to accept the bill as amended, and to clarify, it allows people that have felony convictions to serve on juries. It prohibits people that have pending cases from serving on juries. It allows people that are on potentially a misdemeanor probation to serve on a jury, but it would preclude a person that's on a felony probation from serving on a jury, correct?
That's all correct.
All right, so I think it's a great bill, the way it's amended, and I'd move the bill.
So,
I also believe it passed the House in some similar form, not that we care.
go ahead, counsel.
So it passed the House clean. Literally, the only difference between the House version and the amendment is just that it puts 5 back into law. That's literally the only change. That's has a charge pending in federal or state court of record of a crime punishable by imprisonment exceeding 1 year. So the House passed it clean. As the bill as introduced had deleted 5 in its entirety. So the amendment literally just puts that back in. That's the only thing it does.
Senator Cassidy.
About that, it wasn't what I pushed my button for, but so the House version took out 5?
So the House version is identical to the bill as introduced, which deletes 5.
Okay. The bill as introduced deleted 5. Okay. Oh, I see there's a bracket way up there. Okay. It deleted half of 4 and the first half of 5. Okay, I gotcha. Okay. All right. People are going to vote where they're going to want to on this one. To me, the idea that somebody's sitting on a jury while they're on probation, so the same police who are guarding that prisoner are the same police who, you get somebody who's got the authorities are looking at them for to make sure they're obeying the law. Meanwhile, they're charged with telling us whether somebody else violated the law. I mean, probation is part of your sentence. It's not an attaboy or something like that. We're giving you 5 years to serve and put you on probation or 10 years. You serve 5 and you get on 2 years probation. So it's part of the sentence. And the sentence says you're not in jail, but you're out on probation. And whether that's misdemeanor or felony doesn't really matter. You're still under court supervision to see if you know how to be a good citizen. And the court's watching you, society's watching you. Say, have you come about? Have you done what you're supposed to do? And we're going to have people who are still like having the students in charge of the class. It doesn't make any sense. No, they haven't proven themselves yet. And you got to prove yourself. You do the crime, you do the time, and you don't sit in judgment of other people while you're still on probation. I think it also raises the question, I think Senator Rest raised yesterday, that these folks are going to they would be incentivized either way to go for either the prosecutor or the defense. They're vulnerable to go either way, and I think that's a risk. And it's not like we got to stuff the jury pools or anything, So we ought to just have a clean rule, make it simple, have it logical, and this doesn't go there, because there's some really bad misdemeanors. Thank you.
So, two quick things. One, I just want to make it clear that even though we do think about the criminal context a great deal, we're also talking about jury pools being for non-criminal cases, for civil cases. And I would posit that someone that might be on probation for a misdemeanor minor offense that we've decided in our laws doesn't rise to the level of felony. Many people could be on probation. Many people are on probation for driving on a suspended license, for driving while intoxicated, for other minor offenses under our criminal laws. Certainly, because of that, I would argue they shouldn't be precluded from serving on a civil jury or a criminal jury. But
If nobody cares, either side.
anyway, so, I mean, I think this modernizes Maryland. I think it also helps to enfranchise large swaths of people that are now precluded from jury service and full citizenship. It also, in a very, subtle way, helps us in our constituencies because it increases the potential pool of jurors. I also believe that it's important to have diversity, and West might appreciate this a little bit. And I'm sorry, I didn't mean to pick on you, Senator West. But I remember I was representing a young woman who was, she worked in a hair salon, and she was found guilty. She pled guilty to writing bad checks. And where she worked, and the people that came in, many of them were poor, they didn't have bank accounts. So she would actually, some kind of way, sort of like act as a bank. Like she'd take money and write checks, and some kind of way it got to be a big mess. And I remember that there were persons in court, and I can't claim they were on the jury. They weren't. It was in Baltimore County, though, who made comments in court that I can't imagine anyone not having a bank account. And I remember thinking, well, that's exactly the whole problem. The fact that there are actually people who are so are so chained to their own set of circumstances that they can't even fathom that of a class that's completely different. And so, to me, that highlights this one little way to highlight why we need to have diversity. If any of us were having a case, civil or criminal, especially criminal though, having people sit in judgment of us, we'd want diversity. We'd want people that we feel could relate to us in our circumstances, period. And so I just think this opens it up and makes it better. I know that you're not going to agree, Senator Castley. I just feel like being on, so another big, huge issue, and I brought up yesterday, the process called voir dire is a process I trust. Each attorney is looking out for their own client's best interest. So each attorney is a shield from being able to allow just anyone to serve on a jury that is biased. And for the record, the only thing we need to be concerned about is whether or not the person can be fair. That is the only consideration. Can the person be fair? All the other stuff really is out of the window. That's the only real disqualifier. Person cannot be fair. So
that's I'm riding with you. I just for the conversation, like, so it's for fairness. Are you worried about the influence that still being under probation, regardless of whatever the infraction is, a misdemeanor, felony, whatever? But are you worried about the fact that you're still under on probation, that could bias you in your decision making, or there are different influences on you because you're presumably sitting in the same jury pool where you were, you had the entanglement with the criminal justice system in the first place?
Because everybody that falls into certain circumstances, they're not monolithic people. So I could be a person that's on probation and I'm really mad. I'm like, this is disgusting. And I'm an evil person and I want everybody else to have to go through the hell that I'm going through too. Or I could be on probation and say, hey, this is not something I want to have happen to anyone else. So, I mean, we bring our histories, our backgrounds, our circumstances into the situation, but we don't know what is going on to the head of any juror, to be honest with you. Again, the issue is, can they be fair? And if the attorneys don't think so or the court doesn't think so, they'll boot them out. So that's my thought. I mean, not only that, probation runs the gamut. there is unsupervised probation where people don't even know they're on probation. Like there's no reporting. There's no anything they have to do. The court says, hey, you're on 18 months unsupervised probation. If they never get into a problem with the law, they completely forget they're on probation, essentially, until, the thing is up. Then there's other people who have rigorous probation. I've got to report every week. I've got to take drug and alcohol tests and submit it every week. I have to go to anger management. I have to jump through a whole lot of hurdles and a lot of hoops. So probation is a very broad thing. Many people get put on probation. I don't know. It's your will. But to be honest with you, I just think that's it's not necessary to bar people. I mean, we didn't bar people on probation when it comes to voting. They can vote. And a whole other thing, really quickly. Last thing I'm going to say, maybe. This is important, though. No, this is really important. When people are on probation and parole, they are generally required to earn an income, to get a job, to pay taxes, and contribute to society. And so, to me, it is very hypocritical to say, on one hand, we want you to be a taxpayer, we want you to be a full citizen, but then still deprive them of an aspect of full citizenship. It's blatantly unfair and hypocritical. And so, my argument is, how do you expect people to reintegrate back into society fully if you're still going to bar them at this stage? If that is the case, then tell people on parole and probation, hey, until you're finished with parole and probation, you don't have to work. You don't have to pay any taxes. You don't have to do anything good. I mean, to me, that makes sense. But it's hypocritical to say, on one hand, we want you to participate in society fully, but we're still going to deprive you of one of your rights and privileges in society. So to me, that's the hypocrisy there.
So jury service is a duty, not a right. So let's get that one right up front. I'm just curious. I know that one of the questions that can be asked in a voir dire is, has anyone here ever been a victim of a violent crime or a crime? Right? That's a fair question in a voir dire. Right. So I assume then it's going to be a fair question. You would agree to say, has anybody here ever been convicted of a crime? Has anyone here done time? Or are they doing time? Right? So now we're going to have a jury pool where we've got people saying, and that's fair. It's people can strike. They can say, well, she was a victim of a violent crime. This case is about a crime, so we want to strike her off, him off, and all that. So, but eventually you run out of strikes. You have a jury sitting there, and some people are going to be victims of crime, and some people are going to be people with histories of crime. And now they're going to go back, and some of them might resent each other, and there might be a division and discussions more about your crime as opposed to this guy's crime, and now this guy's sort of an expert in crime, and he can talk about his crime. I see this as a huge distraction, because now when we start introducing into the voir dire, and all the jurors are sitting there, and they're hearing, anybody ever been convicted of a crime? Come on up here, Mr. Juror number 32. And now that's an issue, and we have to go through his crime and how that relates, and then the prosecutor's going to have to say, well, let me use one of my strikes. I can't strike him for cause because the General Assembly already said this isn't for cause, so because he can still sit here. So now I get a, I'm sorry, I can't use I have to use one of my preemptory strikes to remove this person. We're introducing a whole new dynamic, I think, in the jury pool that could be quite interesting. I mean, normally in even like automobile accident cases, people strike people who have themselves had automobile accidents, not because they hate them, but because they don't want to introduce that whole dynamic into the jury discussion. They want people who are more not thinking about their own personal cases, but everything else. And so we've got that issue. We've got that the voir dire puts the prosecution behind when the defendant already gets more voir dire questions, more strikes that they can use. And the idea that somehow, then we also have the issue that somehow somebody who just got out of jail, their constitutional rights are at great jeopardy because we're not letting them serve on juries. I find that argument just specious at best. The fact that, again, I'm sympathetic for the person who says, I've been out for 20 years. At some point, you got to say, enough is enough. Those are the easy calls. As you come back into, still on probation, I think the logic goes away real fast, especially when you say still on probation for any crime, because you're still under the sentence technically. At some point, society, At some point, society has a right to demand appropriate behavior of people. And at some point, maybe we should say that the fact that you transgress against society, you caused people hurt, you disrupted people's lives, you made us spend money to arrest you, try you, confine you, that you sort of, we're moving, you're in a different class of people for a while. Eventually you'll come out, but I don't, we're depriving of their liberties, their constitutional rights, they're great people. It's like, no, you screwed up. You transgressed against all of us. You ruined us. You ruined our society. And we have a right to say no, no, and no again. And this, oh my gosh, we have to all feel really guilty and sorry that you can't serve on a jury while you're still on probation is ludicrous. So, thank you.
Well, I don't want to argue until I'm blue in the face. I think that we're excluding people that are still serving the sentence and on probation for felonies. Misdemeanors tend to be pretty minor things. They're not limited to criminal cases. It's your will. This doesn't make any sense that we struggle so much with instilling full citizenship into people.
Right now we're on a clean bill. We haven't adopted any of the amendments.
Make a motion then?
Yeah.
I make a motion to adopt it minus the people that are currently pending, have current pending crimes, misdemeanors or felonies.
That's this one.
So adopt the amendment in front of you with the exception of the current pending misdemeanors and felonies.
So look, just so council's going to reread that. Sure.
So basically all you're going to do is allow felons to serve, who've currently served their time.
Is this what you want?
So, yeah, everything would be, all I want to offer as the amendment is to remove from the current law felons who have currently served their time, to say they are eligible, and make ineligible felons or misdemeanors, anyone who's not completed their sentence.
With a sentence over a year.
Yes.
I get it. You're saying if you've been sentenced to anything that the time could be over a year and you're not finished serving the sentence, that you could not serve on a jury.
Yes, I'm offering that.
While you're still on probation, but then it also brings in people who have been convicted of a felony. So now those folks who have though they've been convicted of a felony, now can be back in on a jury pool, as long as they finish the probation.
Well, that's fine. I mean, for what it's worth, and I know that I've heard some people in this committee say they're tired of these discussions that keep talking about race all the time, but the truth is that these laws were put into place, many of them, to disenfranchise black people, and ostensibly we're at a point now where we're trying to do some reckoning with our bad laws and bad policies that have done that. I see this as just one of many steps in that direction. I also just don't believe, unlike maybe some other people on the committee, I believe that we have a sentence and that's what the person's to do, and when they're finished with it, they're finished with it. I mean, if you can toy around with the probation if you want to. I wouldn't do it, but if that's the committee's will, we'll have to go to conference committee anyway.
So there's been an amendment offered. Senator Carter spoken. Senator Castley, go ahead and speak, and then we'll run this or adopt it or whatever, and we'll see what happens. So go ahead, Senator.
We've always been pretty candid and open in this committee, and I think how in past years where we've had pretty heated discussions across the various desks on every issue. I mean, it didn't matter what it was, we've been pretty open. And we've been saying, and Senator Carter sent me the study from yesterday that I asked her about, and I thank you, talking about the racial disparity, which shows that there's a racial disparity, which we all knew, between incarceration of blacks in this state versus white, but on a percentage of the population. That there clearly is a disparity, and it's a substantial disparity. But the only thing I've heard this session is that can only be attributable to institutional bias or a bias in the system. Well, I'm sorry, anybody who wants to be objective about this knows that's not true. Everybody knows that our urban centers have there are no families, no fathers, schools are terrible. At some point we have to recognize this. And so it's just not helpful to keep moving on to that kick. And I find it really not at all moving the ball forward. And is there racism in the systems here and there? Yeah, but that's the only thing that we're focused on, Senator. And I think we're really doing ourselves a big disservice to measure every bill in this lens that the only reason is that. I mean, we have music that glorifies misogyny and gangs and murder and rape, and we have a total allowance of fatherlessness in the homes, schools that are terrible, a government that doesn't seem to really care a whole lot. It's just, on and on and on, the litany of problems. And those aren't being addressed because it's like the only thing we want to put up is, well, it's the police motivated by institutional racism. I'm just finding this not very helpful as we analyze all these bills to keep just, throwing that out there as sort of this universal get by.
We got an amendment before us. I'm going to ask council to clarify it, but then I want Senator Sidnor to go ahead and chime in before we have a re-explanation of the amendment, and then we'll roll it. So good. Yeah. Good, Senator Carter.
But
go ahead.
So the amendment prior to Huff's amendment, we didn't take that up, and I know it will be in a flash of light, but I don't think his amendment was seconded, so I don't want to skip to his amendment as if your original amendment is no longer on the table.
I quashed it. I already quashed. I mean,
all right.
Senator Sidnor. But let's explain this amendment first, because I don't think people understand quite. Yeah, but go ahead, Senator Sidnor.
Thank you. And this isn't on the bill, and as I'm listening to this discussion, I just want our good senator to know that I'm from Baltimore City, and I had a father. And I have a number of friends who also had fathers. And fatherlessness is not something that is just affecting the African American community. So that's all I wanted to say. When that comment kind of it rubbed me the wrong way.
No, I appreciate that. Thank you. Okay, so council explain, and then I'll explain, and then we'll go forward.
So the proposed amendment would put paragraph 5 back to current law, so it would put it back into the bill. Paragraph 4 would be amended as such. An individual is disqualified for jury service if they have been convicted in a federal or state court of record of a crime punishable by imprisonment exceeding 1 year and is currently serving the sentence imposed for the conviction, including any term of probation.
So what the bill does now is, so you understand that piece, but what the bill also does is, where in current law, and correct me if I'm wrong, counsel, if you were convicted of, let's say, a felony and then served a term of imprisonment for, longer than a year, then you were permanently excluded. So now those folks are brought back into the jury pool, and now what we've done with this amendment is say, look, if you're on probation, still serving probation, if you've been convicted of a crime in federal state court that is punishable by more than 1 year, and you're still on. Once you're off, you're in again. And we've re-enfranchised, if you will, if you want to use that phrase, people that were convicted of a felony and had served. So that's a big, giant step, and all this is saying is that, look, if you're still on parole or you're still on probation, we just want to wait till you get off. I mean, for me, I'm just personally speaking, for me, that seems level set for me, because there's just too much room for just interference and undue influence when you're involved in the same court system. You're going to sit on a jury in the same courthouse that convicted you for a crime less than a year ago. So this seems good to me, and I feel it's a giant step forward. So I like that amendment, but. Okay with that? You want a roll call, or everybody's fine? All right. Now the bill's before you as amended. Motion for favorable? With amendment? Okay. Do we need to do a roll call? Yeah. Okay.
Vice Chair Waldstreicher.
Yes.
Senator Lee.
Yes.
Senator Castle.
Pass.
Senator Hedelman.
Yes.
Senator West.
Yes.
Senator Sidnor.
Yes.
I'm sorry.
Yes.
Senator Jackson.
Yes.
Senator Bailey.
Pass.
Senator Carter.
Yes.
Senator Huff.
No, and I'd actually explain my vote real quick. So I am actually very cautious about creating new felonies. I've talked about it before. There's a list of collateral consequences about that thick. You know, you can't own a gun anymore. You can't. I mean, it's just a massive thing. Licenses and everything to the state. But just talk real quick about, there's a reason there was those collateral consequences. They actually go back as old as Western civilization. They go back to all the way during the Roman period, where you would lose your Roman citizenship and lose your rights as a Roman when you committed, high crime. So it goes all the way back to that. And there are hundreds and hundreds of collateral consequences. And so I'm not convinced that we need to have felons on there. I think the bill's better than it was, but.
Senator Casserly.
No.
Senator Bailey.
No.
Chairman Smith.
Yes. And I explained my vote. Okay.
Bill passes.
Senate Bill 250. Sorry, could we go Senator Lee if she has something to say?
Okay.
Let's have council
I
speak first.
respectfully ask my colleagues to please vote for this bill as is. It's already passed the House of Delegates. It would just merely repeal marriage as a defense to sex crimes, first degree, second degree, rape, third degree, or sexual assault or fourth degree sexual offense. I think this defense is something like when we repealed the sodomy law, because it is very archaic and it's root in an outdated notion that marriage is consent to and to not allow your spouse to control their own bodies. This is not the dark ages. I think this is a time we need to move forward, just like we did when we repealed the sodomy laws. This defense also creates an inequality between married and unmarried cohabitants, and I think it's very unfair. I think we need to move forward on this, and I think we should pass the bill as is. I've been married for 30 years, believe it or not, and I think that this defense, degrades the sacred institution of marriage, because marriage should always be based on consent, respect, and mutual dignity for each other. So I respectfully ask my colleagues, please pass this bill.
Thank you, Mr. Chairman. So just a quick summary. Senate Bill 250 repeals the exemption from prosecution for certain sexual crimes if, at the time of the alleged rape or sex offense, the person was the victim's legal spouse. There are 3 amendments in the voting packet, and I can review those for the committee when you'd like me to review them, or sure.
Oh, well, I was just going to mention that I had amendments, and I don't know if we're going to talk about them, or I can. So in voicing one of the bills that I really don't like speaking against the most, and I realize that it's a very unpopular opinion among many circles that I have, when you characterize the bill as, hey, we're just, creating equality to some extent because a couple that's not married is not subject to spousal defense, but a couple that is, certainly it sounds preposterous that we would want to deny that kind of equality of treatment to people that are married. However, it's a bit disingenuous to limit the discussion to just if you're married or not married, or if you're going together, there's no spousal defense, then you get married and then there's defense. Because we're talking about something that, as long as we include fourth-degree sex offense as a crime when it comes to people that are in intimate relationships, whether they be married or not, I think that we defy the intent of fourth-degree sex offense and what that was supposed to mean. If you look at our statute for fourth-degree sex offense, which is the lowest level sex offense there can be, you will see that it's very broad and it encompasses a lot. And the first part of it makes sense because it talks about persons in authority, which Senator Bailey was talking about, that, commit an unwarranted act against someone else. That makes sense. Fourth-degree sex offense is an offensive touching, a sexual touching. It's for the purpose, I don't have it in front of me today, of course. Back when I thought we might have dealt with this, I think I had it, but I looked it up, and it's a touching for the purpose of sexual gratification or sexual arousal. And the problem I'm having is that loose language. People that are in intimate relationships, whether they be married or not, tend to touch each other for sexual arousal. Now, you get into a really kind of messy area when you don't tighten up that language and you allow it. It actually makes sense that someone you don't know or someone that you're not having a sexual relationship with, that if they touched you in a sexual way to get sexual arousal without your consent, of course, I could see that being a crime. It makes sense. But someone that you're already having a sexual relationship with that touches you for sexual arousal, it just, to me, is too slippery a slope. It's, if we're honest, and I don't enjoy having this conversation, but I have to, if we're honest with ourselves, every intimate couple, every couple that's engaged in sexual acts, there is some point when one party attempts to touch one and the other doesn't want to be touched. And so I'm really concerned about weaponization of this as we move toward solidifying it in this bill. And so initially we had conversations and I thought, hey, let's just take fourth-degree sex offense out of this and that's an answer. But I thought about it because, Susan and a lot of the advocates talk about the disparity between people that are not married and those that are married. And what I really believe is that we need to relook at fourth-degree sex offense altogether. And we need to take fourth-degree sex offense out of being a crime for intimate couples that are having sex with each other anyway. And all of that being said, all of this can be handled in a crime that's already on the books called assault. So my first amendment that I would propose is that we exclude intimate partners from fourth-degree sex offense, which I repeat is touching a sexual part of another for sexual arousal or gratification. That might not be the exact language, but that's the gist of what it means, what it is. It can be through clothes, and it doesn't have to be harmful. It's just the other person doesn't want to be touched there. I really think that we do a disservice in continuing down this road, and I understand that my opinion is probably not popular with a lot of people, but it's the truth. I'm concerned because we don't want to just kind of over-police intimate relationships, in my opinion. At least we shouldn't. Now, do I believe that it is possible for someone in an intimate relationship to be touched in a way that they haven't consented to and that it's unwanted? Yes. And I do believe that assault handles that if it gets to that point. But what I honestly believe is that if you're in an intimate sexual relationship with someone and they touch you and you don't want to be touched, you simply tell them not to touch you. Okay? And that if that doesn't end there, then you take other steps, like maybe you end the relationship or maybe you leave the place. And maybe if it's done like repeatedly in a way that's harmful to you or super offensive, maybe at that point it could rise to some level of a crime. But right now, we're saying that not only is a crime, it's not only a crime, but a person could actually be put on the sexual offender registry for this. It's going too far. So I really believe it's going too far. And rather than just say what I would initially have said is let's take out fourth degree for this bill, I'm saying let's take a look at fourth degree for all intimate partners in sexual relationships. That's my suggestion.
Senator Carter, that we have to deal with this fourth-degree sexual offense probably in another bill, if you do have these concerns. And I think what you're doing is, by your amendment, you're creating a new group who can use this defense against fourth-degree sex offense. And I don't think that's what our intent was, is to create a new category of people that can use this defense. When someone does a intentional touching of the genital, anal, or other intimate area for sexual arousal of gratification or for the abuse of the either party. Now, what a fourth-degree sex offense does not include is what they call a common expression of familial friendly affection. And I think that if you're in a relationship, you know what that is. And if someone says no, they mean no. And so I would ask the committee to reject this amendment, because you're also creating new law, too. You're creating a new category of people that can use this defense, intimate partners. I don't think that's what we meant to do. And also, we were told during the hearing by the state's attorney that they really do not, there is not a slew of prosecutions for fourth-degree sexual offense, because very often they prefer to prosecute for second-degree assault, because if the two charges will merge, and the defendant will only get 1 year versus 10 years if it was just second-degree assault. So, unless you know of a barrage of cases where this has happened, where there's been prosecutions for fourth-degree sexual offense, I haven't heard of one.
First, I'd like to second Senator Carter's amendment. And I say fourth-degree sex offense is a newer creation. It's in the last couple of years we created it. And it was for the idea that if you had a situation where you did not want to charge it as a second degree, if you had, the example that was always used in the committee was if you had a stranger walk up on a beach and grab someone in their bathing suit area, you're like, hey, that's not really assault. We want that person to be registered. We wanted to charge them different. We wanted to carry the collateral consequences of being a sex offense. So it was never in the discussions do I ever remember this ever coming up about intimate relationships and partners and being used in that. And so it's actually kind of stunning to me that we're at this point with it. And actually, Senator Lee undercut her own argument for it. Because if you make it a fourth degree, it goes from, I actually thought a fourth degree was 3 years. You said it's 1 year, so I'll take your word on 1 year. It goes from a 10-year offense you can have on a second degree all the way down to a 1 year. So you're actually lowering the penalty by putting this in there. Because if a second degree and a fourth degree basically have the same elements, if you put this amendment on and the state's attorney start charging it, you're actually turning a 10-year into a 1 year. So why we'd actually want to do that, I don't know. And then it gets into, I think Senator Carter said it well, gets into criminalizing intimate touching between intimate partners. And this is just a classic overcriminalization, a classic example of overcriminalization. Sex offenses, having that on your record and having the collateral consequences that come with it, I mean, that's just, I think that's a wrong step to go. And lastly, I'll say a fourth degree sex offense has a statute of limitations of 1 year, meaning that a married couple, if there is an assault that happens, a divorce case, if within that year period, the other partner, in order to retaliate, wants to charge a fourth degree sex offense that they charge me in an intimate area for their own arousal, they can do that. So not only does this actually lessen the penalties, and it will be used by people if they assault their wives, and then they can just come back and countercharge within a whole year of statute of limitations on their partner, that within the last year, if they've touched them at all intimately or they used it in divorce, this will be weaponized to use against each other because of the statute of limitations. So with that, I will second Senator Carter's amendment. I think the remaining part of the bill deals with third-degree rape, just so the public understands, too, because I think the public has been misled on this. First-degree rape and second-degree rape, if you're married, is against the law in Maryland. This bill is seeking to add third-degree, which I would agree, that was what the case that came in on the bill was testified to. I don't remember a fourth degree ever coming in on this. and this bill seeks to add fourth degree. I support Senator Carr's amendment, which would remove fourth degree, because I don't think it's appropriate for this, and I would support the bill moving forward, which is just removing third degree as a defense.
All right, so let's go. I want to give, you have an amendment's been offered, it's been seconded, but I want to give the sponsor of the bill wanted to respond. It's still open for, and then we can go to Senator Cassidy if you have something to say, but go ahead, Senator Lee.
Your problem right now, issue is fourth degree sexual offense. And I think that has to be dealt with in another bill. And if you want to do that bill, I'll be glad to work with you on that. But I don't think that is a proper amendment for this bill. What we want to do is just eliminate the defense for sexual offenses if you're in a marital situation, and remove the inequality between married and non-married couples. So I don't think I would be encouraged to get married if I think that my spouse would be free of prosecution if that spouse raped me or committed a sexual offense against me. I think we should just remove. This is the only defense that exists against sexual crimes. Marital, just because you're married.
Yeah, I think the bill actually strikes the entire defense for, I mean, the brackets are at the beginning and the end of the statute. It just cuts it out for everybody. But just to be clear, so if you have an unwanted sexual touching in a marriage or intimate, I'm going to go with Senator Carter's example. If we have such a touching, I guess your various options are, your first is say no, go away. Under Senator Lee's bill, it would be no, no, no. You just committed a crime. There is no go away. You touched them. There was not consent, so there's a crime. Under what Senator Carter proposes is you said no. Now, if they persist, now it's an assault, potentially. Or you also have the choice of, so you could charge them criminally under assault, or you can go for protective order because it's either a marriage or established intimate relationship. You go for protective order and get a protective order, have the person stay away. You can actually put them out of the home. You can even have them pay you money, possibly get the car, maybe get some family support. Or you could, if it's a marriage situation, you can file for divorce or on the basis that they committed a crime against you. So there's lots of options here, and I guess what we have to decide as this body is when you had that unconsented touching, which when the touch was made, it may have been totally appropriate and welcomed, or it was, for whatever reason, not welcomed. It was probably welcomed on previous occasions where you weren't in an intimate relationship, and so now it's not welcomed. And so the response under Senator Lee's is, that's a crime. We're going to bring the cops in, and we're going to charge them with the crime. So do we jump right there, or do we jump into all these other options that we've created for people who find themselves in a relationship that is for whatever reason, is no longer appropriate? Thank you.
All right, go ahead, Senator Lee.
The prosecutor would have to prove beyond a reasonable doubt. It's a lot easier to prove second-degree assault than fourth-degree sexual offense, because it has to be beyond a reasonable doubt. And that's why I don't think that this is... listen, no means no. There has to be consent. That's the bottom line, and you have to look at the facts. The court and prosecutors have to look at the facts. Prior, current behavior, whether or not there was consent before, explicit or implicit.
Thanks, Mr. Chair. I just wanted to restate something I've stated several other times this session in other bills, which is that very few cases actually get to the point of trial where a determination is made beyond a reasonable doubt. The concern that I have, and it's a legitimate concern, is that the second this is claimed, the person that it's used against is going to be arrested because it's deemed something so salacious as sexual assault, even though it's fourth degree, which doesn't even require intercourse or anything beyond a touching, they're going to be held without bail because that's what they do. That's what commissioners do when there's any allegation of anything domestic. They really do. And judges usually will, use greater discretion, and if the situation warrants, give the person some type of relief. But I'm really concerned about the fact that it can be, and it will be, not can be, it will be weaponized. And I just think that it's an unnecessary step that I think we need to revisit the fourth degree. I mean, if you think about it, it's kind of insane that it goes all the way from a person in position of an authority that abuses a minor, people that are strangers, to people that could be already in a sexual relationship. It really doesn't make a whole lot of sense. And at the very least, there should be some requirement of notice, because, this doesn't even require someone to even have any reason to know that they're doing anything offensive. So that's my problem.
Well, just a re-clarification of what your amendment does. Who's your counsel? You're just extending this to unmarried couples, right? Is that the amendment? The extent of
Right, so it's, just for the committee, it's amendment 933226/1, and it would provide that a person may not be prosecuted under 3308, which is for fourth-degree sexual offense, for a crime against a victim who was the person's legal spouse or intimate partner at the time of the alleged rape or sexual offense. Actually, that needs a technical amendment to strike rape. Right. So, and that's the provision of code that's provided for. It wouldn't apply, however, if the spouse or intimate partner, this mirrors current law, live apart without cohabitation and without interruption, and then it has clarifying language there. It also provides that a person who is convicted under 3308 of the criminal law article, so that's the fourth-degree sex offense, may not be required to register on the sex offender registry until, under Title 11, Subtitle 7 of the Criminal Procedure Article.
Moved on favorable. It's fine. Just vote against it. No, just roll it. No, it's moved favorable. It's been moved favorable. It's been seconded. So we'll just vote against the unfavorable if you don't want. The amendment has been moved favorable and that it has been seconded. So we'll roll it that way. See what happens.
Vice Chair Waldstraker.
No.
Senator Lee.
No.
Senator Castley.
Yes.
Senator Heddleman.
No.
Senator West.
Yes.
Senator Signor.
No.
Senator Jackson.
Pass.
Senator Bailey.
Yes.
Senator Carter.
Yes.
Senator Huff.
Yes.
Senator Jackson.
No.
Chairman Smith.
No.
Amendment fails.
Thanks. Further discussion? Senator West, go ahead.
So with the failure of that amendment, is my understanding correct that the bill currently provides that if a husband rolls over in bed and touches his wife to initiate sex, that would be a fourth-degree sex offense, and that the prosecutor could indict the husband for a fourth-degree sex offense if this bill passes? No.
If that is just a common expression of familial or friendly affection, it would not. Plus, the prosecutor would have to prove beyond a reasonable doubt. I don't think that would ever happen. I mean, that scenario, really.
About indictment, not whether or not he could prove the case, but could the prosecutor indict the husband for a fourth-degree sex offense?
And you would have to look and see you would have to look at their prior conduct, current conduct. You have to look at the facts. It's a trier of facts.
I'm sorry, where's the provision in here about familial, where is that?
I believe that's case law.
No, she's citing the statute, which is the definition of sexual contact, which does not include a common expression of familial or
I
friendly
believe it's case
affection
law.
or an act for an accepted medical purpose, which is under the definition, section 3-301. It's in the supplement, but that's what she's citing.
A definition from what, the dictionary?
May I ask, Senator West, I was going to clarify too, it is from the statute, specifically, the definition is a person may not engage in sexual contact with another without consent of another, sexual contact being defined as the intentional touching of a victim's genital, anal, or other intimate area for the purpose of sexual arousal or gratification. My concern is your concern. Now, it does say sexual contact does not, down further in section 2, sexual contact does not include a common expression of familial or friendly affection. I just don't think that's enough of a protection, because familial affection could be just like a hug or, something like that. But we're talking about sexual contact, touching a sexual area for sexual arousal. My concern is that is what people in intimate relationships do. That's what they do, and that is not exactly the same as just a familiar or friendly affection touch. It's not like a kiss on the cheek, which is a familial friendly touch. We're talking about people that are in consensual, ostensibly, consensual sexual relationships. There is no defined language for how people choose to conduct themselves in those relationships.
If we all agree that my hypothetical situation should not give rise to a prosecution, and I would hope we will be, that we are, why can't we devise language which would supplement the phrase familial relationship and would make it clear that two individuals who are in a sexual relationship can engage in this sort of activity without it rising to the level of a fourth-degree sexual offense?
Can the one part of the conversation that we're not kind of filtering out here is this, so yes, you've established this pattern of contact, it's the normal cadence of your relationship, but then what happens when that happens once and it's not consented to?
It's a second-degree assault.
And that's, I get it, so that's what we're playing around with here. And so that's the that's the problem.
And my point is that inevitably, in the course of any relationship, that is bound to happen. It is bound to happen. It is a predictive inevitability that at some point in everyone's relationship, sorry to offend anyone's egos in here, there is a time when one partner makes that advance and the other one is not receptive to it. And if we leave this as it is, I just believe we are leaving this door open for that to become more of a problem and be weaponized and used to criminalize. And that's my concern.
I mean, here's my question. If familiar touching is not defined, how are you citing that as a defense? To me, familiar touching is giving a hug or a pat on the back or something like that, as a colleague would walk up to a colleague or a friend to a friend. fourth-degree sex offense, the elements are exactly what Senator West mentioned. So why do you think that familiar touching is in any way a defense to Senator West? Because it seems not to be defined. Is this a dictionary definition, or? My layman's interpretation is familiar touching. If I walk up to Senator Carter and give her a hug on the Senate floor or something, that would fall under that. Versus Senator West, that's clearly all the elements of a fourth-degree offense. He's just his definition.
Some creative draftsmanship ought to be able to surmount this problem. It's not that complicated.
Good.
I think the issue is fourth degree sexual offense, and I think that is something for another bill. And we have not had a hearing on that, and we could address that in another bill. Chris, the prosecution said they rarely
All right.
prosecute for fourth degree.
Chris is trying to work on amendments. Hold it for a day.
No. We're not holding this.
Not worth the money and resources to do it. And I think there are issues with fourth degree sexual offense,
Right.
which you got to deal with in another bill.
So I just want to offer a reason why we don't want to go here. It's because there's a strong preference when relationships are going sour, not to criminalize it, but to push it into the courts, the family courts, the civil courts, deal with it there. Clearly, if there's an aggression, it can go right to the criminal courts. If she says no, and by the way, just go away, and now, slaps her, or she slaps him, or grabs them, now you're an assault. So that's a whole different bailiwick. What we're talking about is that initial time when it's realized that no, when I don't need to tell you no, don't even reach over here. That initial time we generally push into the family courts, the civil courts, because we don't need to criminalize it. There's no benefit to society to criminalize that kind of behavior. Certainly people shouldn't be forced into relationships, required to stay in a relationship because of poverty or economic dominance or physical dominance. None of that. But we've set up the legal mechanisms to protect those people in the law. And because we've set those up, the courts would prefer not to bring the criminal courts into the bedroom. That's why we changed the sodomy laws. Even though nobody was being prosecuted for it, the idea was that you shouldn't have, the criminal law shouldn't be in the bedroom except under, when it's clearly needed. But we don't need to bring the police into the bedroom. We don't need people being brought before the prosecutors to defend what they did in the bedroom that day. It's just not where we want to go with society. And this sort of irrational push just to simply say, what we're going on here, we have a bill that says, it's great, it's written by the advocates, love is no defense to sexual crimes. I mean, clearly we're pushing a political agenda here, and that's unfortunate because we're not really looking to resolve an issue, we're pushing a political agenda. I think that's unfortunate because this is about relationships, about human sexuality. That's an important topic, and we shouldn't just, for purposes of pushing forward a political agenda, mess with those relationships. Thank you.
Thank you, Mr. Chairman. I disagree that this is a political agenda, and I have a question. I mean, why do we treat this differently if a couple is in a long-term relationship and is intimate and is married and then is not married? It not having consent is not having consent, and I think that we should not treat married people who are in intimate relationships differently. This is the only thing that I can tell that where we do have that difference, and practically, I think there is no difference. And these are precisely the kinds of situations that I think there should be a recourse in a court for. If it's non-consensual, that is not okay, and that is an opportunity for involvement from the outside.
That my opinions are going to be super unpopular here, but here's the thing. There's something about this that bothers me, and it even bothers me from the title of the bill, which is completely misleading, and I think it speaks to that kind of agenda that some of us believe is there. Love is no defense. This bill is not about love. This bill is about we're getting rid of spousal defense. So my additional amendment is that we need to strike the title of that bill. That's misleading, and I have a problem with it because it sends a message to the public that we're doing something that we're not doing. Okay, this is specifically about marriage. The bill title needs to say marriage, spousal defense, eliminating, or whatever it does. But love is not a defense. First of all, this has nothing to do with love because we're already saying that this is about marriage, not intimate partners. Now, I'm saying that assault is never okay. Sexual assault is never okay. But when people are already engaged in a consensual relationship outside of marriage or in the confines of marriage, there's bound to be times when somebody doesn't want to be touched and they're touched. And I get it that I've had experiences that many people here haven't, by being in the criminal justice system, by sitting in courtrooms. Literally, this is the truth. And for when I'm sitting waiting for a case and I see another case in front of me where a defendant, a male defendant, it's a protective order case, and the plaintiff petitioner is represented because they get free counsel from House of Ruth that sit in the courtroom at North Avenue, but the defendant, the respondent, often doesn't have counsel when they have to show up. So I was literally sitting in the court one day years ago, and it resonated with me that once the petitioner made all of her accusations, the respondent went to speak in the court, and the judge says, "Shut up. I don't want to hear anything from you." And then proceeded to, believe everything and order all of this, stay away from your home and stay away from this and that and the other. So that speaks to a bias that exists. And I know that people don't want to recognize that there's a bias, but there is. Anyway, my amendment is get rid of that subtitle, Love is Not a Defense. That's a terrible, terrible, misleading title.
All right, there's amendments open. As you second it, we'll entertain it when we come back for voting. Look, you got 10 minutes to eat before you're on the floor. So let's call it right here now. Just.
Are we coming back after we're done?
No, we're done. We're not coming because we're gonna get off the floor till 9 o'clock. So look, we'll come back tomorrow morning. What time does floor start tomorrow morning?
11.
So let's come back at 9:30 tomorrow. Okay, for voting. 9:30 tomorrow morning. And then we'll start off with the amendment that is open with Senator Carter.
Can I get the floor leader?
Sure. Yeah. Before everyone leaves, let's get floor leaders for the stuff we passed out.
So, Senate Bill 78, Senator Wall Street, your review of ketamine bill? Yeah. Okay. Senate Bill
Why don't you move the
608,
bill?
Senator Jackson, do you want that one? That's your Police Training Commission bill? Sorry. Your Police Training Commission bill, will you take that on the floor? Yes. Okay. Senator Carter, courts, jury service disqualification. Okay.
Are we doing these now or they'll be tomorrow?
They'll be tomorrow.
Because we're already backed up. But we're going to do our old bills now.
Yeah, somehow our calendar keeps getting pushed back. Doesn't want to get to the JPR calendar.
I wonder why.
Why are you looking at me?
Your side of the room is the reason.
That's not. It is.
Your bills are the reason.
So, just go ahead and leave, and if you have any amendments for the rest of this list, leave them here, or, don't delete your email so that when you come, we're not going to re-email them out.
For the record, I think this is cruel and unusual.
I'm sorry.